Hi, this is attorney Sarah Holmes of Holmes Business Law PC, and today's presentation is on trademarks and IP. It's time to take stock of what's valuable in your business. All right, so just quickly a little bit about us and why we're speaking with you today. So I'm Sarah Holmes. I'm an attorney, been an attorney for about 16 years now, and I own a business law firm called Holmes Business Law PC. I have had this law firm for about 8 years now, and I have been a business owner. I've owned a small manufacturing company and I've owned a retail business outside of my law firm. So when I was first starting up a business, I always looked for someone to help me grow my business and protect it legally. And even though I was an attorney, back when I first started practicing law, I did defense litigation. I did court arguments and defended companies. I didn't really do contracts or formations or anything like that. So when I looked for someone to help me with my own business, it was very difficult to find anyone that was willing to help smaller business owners. So when I got an opportunity to open my own firm, I really wanted to help other entrepreneurs and business owners like myself or other people looking to grow businesses and build their own path forward. And that's why I started my business to help exclusively other business owners. Now, we also provide some general counsel services, meaning we are, the outside counsel for businesses. So if you have any legal issue in your business, you can bring it to us. If it's not something we handle or requires a specialist, we will help you find a referral to handle that. Otherwise, we typically handle business formation, hiring employees, labor law compliance, commercial leasing, trademark registration, partnership agreements, contracts, and that's mostly what we do. All right, so today's presentation, though, is about IP. Many people hear the word IP or intellectual property, and they don't know what that means. So what is IP? So first of all, IP stands for intellectual property. Now, those are some big fancy words, but what does that really mean? Well, it means in the context of your business, it's creations of the business. So it could be a number of things. It could be different writings, like if you are doing blog posts for your business, if you're writing copy to sell products, if you are writing instruction manuals, if you are writing reports, any writings that you produce in your business could be considered IP and intellectual property. Photographs, any photos you're taking, if you're taking headshots of your staff, you're taking photos of your products, any kind of photos that you would take for your business. Illustrations, a lot of people do some illustrations for their business. Maybe it's some charts or graphs or hand-drawn things to go with reports. Those, again, fall under IP for your business. It can also be the ideas of your business. Now, this one is very nebulous and sometimes hard to wrap your head around, but some of the ideas are things that, in fact, are intellectual property and IP. It's valuable. It's something that could help your business make money. So therefore, it might be something that falls under your intellectual property. Those ideas belong to either you personally or your business. IP can also be processes that your business uses. It could have a distinct or proprietary way of doing things such that other businesses would be at a disadvantage by not knowing how to do that. That, again, could be valuable intellectual property. That's the type of thing you would want to protect in your business. So process would be, how something is done. It could be a recipe, and now a recipe normally has some other issues with it, but it could be a very particular way of how you're doing something. All right, what are the types of IP? These are some things that most people will recognize, although there's often confusion among them and what each of them does and what they mean. So the first type of IP is a patent. Now, patents are registered with the United States Patent and Trademark Office, which is USPTO. It's an invention typically. So it's an invention itself, meaning like a product that does something. It could be a process, a proprietary process that's very unique in how it's been put together. So you want to think of patents as inventions. And in order to get one of those, you want to use an experienced patent attorney or a patent agent. These are very particular people that have to pass a totally separate bar exam. They don't even have to be lawyers. Most of them have a scientific background, and they take the patent bar, and then they are authorized to practice before the United States Patent and Trademark Office. So patents, you really need a specialist. And for people that call our office looking for a patent or for some kind of invention, we are able to refer them to patent counsel. Copyrights. So copyrights are typically, you have to think of a copyright as a work of art fixed in a tangible form. So it doesn't have to be an artwork per se, like, oh, it's the Mona Lisa worth billions of dollars, not like that, but just some type of thing that's been fixed in space. So that could be going back to a drawing. Okay, you put the drawing on the paper. Now that drawing on the paper is what could get a copyright. It could be a written terms and conditions in your website. That would be a copyright. It could be a novel. It could be an employment manual. It could be copy that you have put on a product to sell on your website. All of those things are things that have been fixed in space. A song, music that's recorded can be subject to a copyright. And copyrights is also something else that can be registered, which we'll talk about in a minute. Trademarks. This is where people get convoluted. It can be trademark and copyrights, and sometimes patents get confused together. So trademark, you have to think of as the brand elements of a business. So brand elements could be a number of things. Brand element could be a logo, a business name, a slogan. Sometimes it's what we call trade dress, meaning what are the proprietary colors or how the business is laid out. You know, like if you go into a franchise, right, and you see that every franchise has the same color scheme, it's all laid out the same way. That could be a trade dress claim. All of those types of things would fall under a trademark. Trademark, again, can be a formal process. We'll get to that in a minute. But trademark, think of as brand elements. Now, a lot of people come to us wanting to trademark hashtags. A hashtag usually on its own, unless you're really using that as a brand source signifier, may not actually qualify as a trademark. So that's why you want to speak to someone about these things to really identify what type of IP you have and which stuff you can protect. Trade secrets. This is not something that people typically think of as IP because it's different than the patents, copyrights, trademarks. A trade secret would be, how about a recipe book for how you make all of your recipes in your bakery? Those are trade secrets. None of those things on their own might qualify for some of these things, maybe a copyright, but the point is trade secrets are things that you would not want a competitor to know and find out about. So trade secret would be how you're doing things. Trade secret would be customer lists, vendor lists. Trade secrets could be how you calculate your pricing, how you package something up. That's all secret stuff that gives you some kind of competitive advantage. And those would all be different types of intellectual property. All right, how do we protect IP? So there's a lot of different ways to protect IP. And when you're thinking about going through your business and visiting some of these items, this is when you, excuse me, what you want to keep in mind. So there's some pieces of IP that you can protect by getting a formal registration for it. And usually that registration is from the government. So for example, with a patent, I already touched on that. That would be a registration with the United States Patent and Trademark Office, USPTO. You would need either a patent attorney or a patent agent to do that work for you. You can write your own patent, but it's usually not advisable. You would really want competent counsel on a patent. Copyright. You could register a copyright with the United States Copyright Office. That requires submitting the work of art. We'll call it a work of art again, but you know, whatever that fixed medium is, you would submit that to the Copyright Office and they would send you a copyright certificate. Trademark. That's another one with USPTO. That is a process that can be more complicated than it appears. And it heavily relies on doing a competent search beforehand and making sure that there is really nothing else out there that might block your mark. They will reject trademark applications for anything that looks like, sounds like, could mean the opposite of, has a word in a foreign meaning. They could reject any of those if someone already has a similar registration in a similar category. So the best protection for any of those types of things would be, in fact, getting a formal registration. And then potentially you are foreclosing anyone else in the United States from using that piece of IP for any, to get a profit or otherwise. Non-disclosure agreement. This is a really, really important way to protect IP if you're going to be dealing with other people. So if you are going to, let's say, enter into a business relationship or a partnership with someone else, and you're going to have to give them some proprietary information in order for them to evaluate the opportunity or, to discuss things with them, you need them to sign a non-disclosure agreement. That will then say, hey, anything I give to you, anything I disclose to you, you can't go and use it on your own. You can't sell it to anyone. You can't do anything with it. You have to give it back to me or destroy it forever and ever, always. Otherwise, I'm going to sue you and get damages. Non-disclosure agreement, very important whenever you have to disclose your ideas or IP to someone else. Now, your processes. How can you protect processes? Well, you should have a process for how you're going to keep this stuff safe. So that could be something like you own a bakery and every night you are locking your recipes in a drawer. You're not just leaving them out for anyone to see. You want stuff to be available on a need to know basis, meaning you're not just giving anyone access to your recipes. Why do the counter people need your recipe if they're not baking your bread? They don't. Only the actual bakers need the recipe for the bread. The more you take steps to protect your IP, the more you will be able to legally enforce and protect those items. But you can't just be sloppy about it, leaving stuff all over the place for anyone to see or use willy-nilly. Next would be by policing your intellectual property. You want to keep an eye out for people that are using your things without permission, stealing them, even inadvertently, accidentally using them. This is really, really important with a trademark. For example, if someone is using your business name or a similar variation of it for a business in a similar type of category, you got to think about how you're going to shut that down. The more you let it go on, the more that person's going to have a valid claim that your rights became diluted, you let them use it, and now, you can't stop them. So it's very important to police your marks and know at all times where your intellectual property is, who's using it, and making sure that use is proper. All right, employment agreements. Employment agreements are really important. You want to make sure that you are clear with your employees how they can use any of your IP, that they can't take it somewhere else, that the things they create for you while you are paying them as an employee belong to your company, not to them as individuals. And for avoidance of any doubt, all of that stuff should be set out and written down in various employment agreements with your employees. That's definitely something that you don't want to tackle on your own, and you should absolutely consult legal counsel for that. It's the same thing or similar with 1099 contractors. If you are hiring 1099 contractors to provide services for your business, maybe it's someone that's going to design a logo. Maybe it's someone taking photographs. Maybe it's a copywriter that's writing articles for you every month. Don't assume that just because you're hiring that person and they're a 1099 contractor, that you own those things they're creating for you. That's a wrong assumption. Usually in the contract, it'll state who owns those things. And you have to be very careful about how that's worded to make sure that your business, in fact, owns those things and not the person that actually created them. All right, the next step would be to evaluate your IP. So take a look at what you have. Think about every day in your business. What are you creating? What are you doing with it? Who has access to it? And what are the industry standards? And by that, we mean, what does your business repeatedly create? If it's repeatedly creating stuff like blog posts, if it's repeatedly creating programs, if it's creating new products and names for those products, that's all IP that your business is creating on a regular basis. Now, what are you doing with these things? Are you releasing this out to the world? Are you launching a new product? Are you entering into a business relationship with it? Is this stuff that has to go through a long period of research and development, and then eventually it'll be released to the public? It's really important to consider where these things are going, like who you're beaming this out to. The more you're taking stuff that you want to keep proprietary, like let's say you have a recipe, right? You own a bakery and you want to keep everything proprietary and that you own it. It's your intellectual property. And you go one day and you post a recipe on Facebook for your fans. Well, now you just kind of took that out of a trade secret. You willingly posted stuff that should have been secret to other people. Same thing, if you're getting sloppy with your customer list or your vendor list or your profit calculations or formulas, and you're just dispersing those to people that don't necessarily need access to that information, you are now potentially giving up some of your trade secret claims by just putting that information out there. And who has access to it? Again, go back to the employees. If there's stuff that you need to keep secret, it needs to be kept secret. It shouldn't be accessible to all the employees. There's a famous story that the formula for Coke, like nobody actually has it. Nobody knows the formula or the recipe. It's locked in a vault somewhere, and maybe like a small handful of people in the entire world actually have access to it or would know how to get it. That's protecting a trade secret. They can't just give that to everybody. They're not going to give it to the guy driving the distribution truck. They're not going to give it to the guy, selling bottles of Coke in the lobby gift store. They're not going to give it to their accounting team. If they did that, again, they're blowing their claim for their trade secret out of the water. So think very carefully about who has access to these things and what you want to do with them. Now, look at your industry standards. Like, what do people typically do in your industry? Do they say, hey, if I hire this person, they create something for me and I own it? Or, is it industry standard that they would own it? An industry that this comes up in a lot is with photographers. If you hire a photographer in your business to take photographs for you, often if you very carefully read their photography agreement, it will say that they own the copyrights to those images, not you, and that they're giving you a limited license to use them. If you want that to be different, you would have to negotiate that with a photographer and actually make sure that winds up in a contract someplace. So it's really important to understand what industry that you're working with and what are the standards and how typically things are done in that industry, because it's all different across the board depending on what kind of industry it's in. All right, and then what do? Well, you should take some action. After you've identified your IP, where it's going, what you're creating, it's time to now think about, do I need to do formal registrations? Should I register this copyright? Should I register my brand name now with a trademark? What do I do about this logo? Those would require formal registrations. That there is a longer process, there's fees. You probably want to consult legal counsel, and that would be a way to protect those items. Documents. If you don't have proper documents in place, if you wait until there's a problem, it's usually too late. Like if you're going to wait until you have a fight with your employee or your business partner about who owns things that were created, it's too late. The genie's out of the bottle. You need to get this stuff in writing on paper, have non-disclosure agreements in place, have proper employment agreements in place, proper 1099 agreements, just to be clear always who owns these things. Because if your business doesn't own it, your business, its value is taking a huge hit if your business can't even prove or show that it owns its own intellectual property. All right, if you have any questions or need help with your intellectual property, if it's a patent, we'll refer you to patent counsel. Trademarks, copyrights, we can help you with. If you want to consult on trade secrets, we can do that as well. But feel free to reach out to our office. The phone number is 215-482-0285. The email is the info@phillysmallbusinesslawyer.com. Happy to help.